Right now on the Daily Debrief in California.
And then he took his pants and then exposed his penis to me.
Accuser after accuser is testifying against a former NFL player on trial for alleged sex crimes. Plus, in South Carolina, a man who killed his 5 kids claims insanity. Does an old brain injury give him an excuse? Real-life criminal trials are on the Daily Debrief. It's Thursday, May 23rd. Welcome to the Debrief, everybody. Glad you're with us. Attorneys Jason Friedman and Brian Buckmire along for the discussion. We begin in California with day 4 of the trial of an NFL player accused of sex crimes with 5 women ranging in ages from 17 to 77. Kellen Winslow II played 10 seasons with the Cleveland Browns. He faces 12 charges, some in multiple counts. The maximum penalty, if convicted, is life with the chance for parole. The accusers are known as Jane Does 1 through 5. We cannot show their faces, but here are some basic facts. Jane Doe number 3 is a 57-year-old woman who lived in the defendant's neighborhood. On May 13, 2018, she said she was gardening when a man approached her and pulled his pants down. She reported the incident the same day and identified her attacker through tattoos. She could not pick Winslow out of a photo lineup. Winslow is charged with indecent exposure as to this alleged victim. The accuser is most comfortable speaking Vietnamese and testified through an interpreter.
What do you remember happening after he walked up behind you on the day you called the police?
The day I was cutting flowers, and then I saw him. I was walking toward the orange tree, and then he was following me. And then he took his pants and then exposed his penis to me.
What did you say to him when you saw him expose his penis to you?
I said, no. I didn't look at his face, and then he walked away.
All right, the record will reflect that witness turned her body and her head to the left as if looking away.
I have to ask you a question that I know is uncomfortable, but when you saw his penis, was it erect, if you know?
Yes.
Did he touch himself?
Yes, he used his hand to hold the penis.
Was he looking at you?
At that moment, I don't know, because I didn't look at his face. When I saw that, I said, no, and then I did not look at his face.
Was he inside your yard?
Yes.
Here is Jane Doe number 3's testimony about her alleged assailant's tattoos.
Can you describe what he looked like?
I saw his body only. I didn't look at his face. So he has a muscular body, like the people who ride the bicycle, like the professional cyclists.
Did you see anything on his arms when he had no sleeves?
Yes.
What did you see on his arm?
Tattoos. I saw his tattoos from here down to the wrist, and it has the flag.
All right, the witness indicated from her shoulder, when she said here, down to her wrist.
The tattoo is from here down to the wrist, and then only one color is the blue color. The blue like the color of the flag.
Can you describe the tattoo on his right arm?
No, I only see one dark color, and then I don't care.
Do you remember seeing them on both arms?
Yes, that is correct.
And of course, this defendant does have tattoos on his arms. The question, is it the right defendant? Now to another accuser. Jane Doe number 2 is 59 years old and described herself as homeless when she says the defendant offered her a ride on May 13, 2018. She reported the next day that he allegedly committed forcible rape and sodomy by force.
He held me, grabbed my arms, and I don't know what else he said, but he says we're gonna have sex. And I said, please don't do this. And I said it about 4 times. And something like, it's a done deal, you know, and
Ms. Doe, let me ask you about that. So when you say that you said, please don't do this, you think you said that about 4 times? Is that a yes?
yes.
And when you say they were held, you're clasping your hands together, did he actually place his hands on your forearms and hold your arms together?
He held my hands together. Yeah.
Tell us what he actually did on the side of the car when you were in the passenger seat.
Well, he had me take my pants off and pulled me on front of the seat and started to, you know, and
So Ms. Doe, I have to ask you, when you say that he started to, you know, what did he actually do?
you know, started to rape me.
During cross-examination, Jane Doe number 2 did not want to look at the man she says raped her.
At the same time, you know, you said that you met Mr. Winslow probably about 6 months prior to this happening, right?
I really don't want to look at him, sir.
You said about 6
I
months.
don't appreciate it.
Appreciate what? What is it you don't appreciate?
That I have to look at my rapist.
Okay.
I think you should be further over.
Now, take a look at him.
No, I don't
Your
want
Honor,
to
I'm
look
going
at
to
him.
object to the last
Just a
question.
moment, just a moment.
Objection, no question pending.
There is no question pending. Ask another question, Mr. Carlos.
Mr. Winslow over here, you've known him for more than 6 months.
I knew him as Kevin. I never knew his last name.
That uncomfortable cross-examination continued with this description of the assailant choking Jane Doe number 2.
Question to you, Ms. Doe, is you described a choking that he did. Do you remember that during direct? Just yes or no?
Say that again. I'm
You just-
sorry. I can't focus, sir. It's because I can't look at you, so it makes it harder. But go ahead. Say it again.
You described a choking event inside of the vehicle. Remember that?
Yes,
or no?
yes, sir.
You described the individual putting both hands around your throat. True or
Yes.
false?
True.
Wait, let me finish the question, please.
Oh,
You described on direct that he applied pressure to your throat so hard that you couldn't breathe. True or false?
true.
Okay. And that would be to your neck. Isn't that true?
It was up really high. And he used both hands.
All right,
You
indicating,
can't use marks. It's,
just a moment, again indicating the upper part of the neck just below the jawbone. She's indicated with both hands on her neck. All right, next question. Listen to the next question.
Ms. Doe, were you shown the pictures of your SART example?
no, I never saw any
Okay.
of them. I know he's pretty smart.
Okay.
I know
You
there's no marks, and I know he ejaculated outside of me because he doesn't want to get caught.
That's a tough accusation. Let's back up now and talk about the first accuser, the so-called Jane Doe number 1. She is a 54-year-old woman who said she was a transient and was hitchhiking when the defendant approached her on March 17, 2018. She reported the alleged crime 4 days later. This accuser's account led to 3 charges: kidnapping, forcible rape, and forcible oral sex. Here is her testimony.
When he got on top of you, did he feel heavy?
Yes.
Did he hold you down in any way?
Well, when he inserted his penis, it hurt so bad. I don't know how I could have even opened up. Because
So Ms. Doe, let me ask you.
okay.
Let me ask you a question. Did it hurt when he penetrated you vaginally with his penis?
Yes, I kept on saying, ow, 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 because I don't know how he fit that thing in there.
Did he push upon you, or did he just push his body against you?
He had his body against me, but he had his hand, like, on my back. Like,
Now,
Well, you're indicating on the right side of your back, is that correct? Where he had his hand?
yeah, he had his hand, like, let's see. Yeah, he had one of his hands on my back. That's all I remember.
Okay, now you're indicating on the left side. All right, next question.
and when you say that he had his hand on your back, was he basically mounting you in the front passenger seat of the vehicle? He was on top of you.
Right, he was on top of me.
Was he able to penetrate you vaginally, though?
Yes, it felt like a bunch of water or something came out. So, like he went in for like a few minutes. I don't even think it was even more than 5 minutes, not even that. And I just felt this heavy gush of water going.
What did you think it was?
Blood.
when you felt
It was
that?
blood.
On cross-examination, the defense picked apart this misidentification. At one point, that witness, Jane Doe number 1, said that the attorney, not the defendant, was her attacker.
You came to court, you testified before the lawyers and the judge, right? Remember that?
Yes,
Okay. And you remember, you pointed out this man
right.
being the individual who raped you. Remember that?
Yes,
Okay. This man I'm standing in front of.
yes.
For the record, this is Mr. Watkins.
The record will so reflect.
And that's still the person who raped you?
No, it's the one next to you, him.
In the prelim, you were pretty sure about
Okay,
it, right?
just a moment for the record. The person next to Mr. Watkins is the defendant. Next question.
But in the prelim, you were pretty sure it was Mr. Watkins. Remember that?
Yes, I did say that.
Joining me on the debrief right now are attorneys Jason Friedman and Brian Buckmire. So I'm represented by a former prosecutor here.
That's right.
And a criminal defense attorney. So Jason, I'll start with you. As a former prosecutor, there are a couple of misidentifications here. There's a lack of a photo identification from Jane Doe number 3. Is this fatal to the state's case, or is this just to be expected in a case where people are saying that they've been severely traumatized?
Yeah, it frequently does happen in this way, so I don't think it's fatal to the case, to answer your question. And don't forget, this is also a case about science. And I would be much more concerned as a prosecutor with these so-called misidentifications if we didn't have solid science, DNA evidence to back things up. So I think that's the saving grace, so to speak, for the
Okay,
prosecution.
yeah, I mean, we've got Jane Doe number 1 at one point identifying the attorney, but they've got the defendant's DNA on her clothes, so they were together somehow. Brian, how does the defense try to override that?
So again, you're going to comment on this, say it was consensual. Their DNA was on the clothes. I think I read that it was the articles of clothing weren't turned over until some months later. You're arguing that this is consent, and as to the DNA, it's not fatal by any way and stretch of the imagination. But you are going to try to say that it's damaging. The fact that you cannot identify your assailant, and you can give very benign reasons, the focus, the trauma, this, but you want to harp on the burden of proof and really say that if you can't believe beyond a reasonable doubt that this is the defendant who committed these crimes, you've got to go not guilty.
I don't know. When the state starts lining all of this up and the evidence starts to stack up, at first I thought this was shaky. The more I hear from these witnesses, the more I'm apt to believe the state's case. Sorry, Brian. I'm going to have to side with Jason's former career on this one. Still ahead on the debrief. 5 children killed by their own father. We've heard of the emotional loss, but now we hear about the defendant's damaged brain. Does it give him a legal excuse for the deaths of those 5 kids? We head back to the courthouse after this. The defense has the case of a South Carolina man accused of murdering his 5 kids. Timothy Jones Jr. could be executed if jurors find him guilty. He admits taking the lives of his children, ages 1 through 8, and then driving around with their bodies in the back of his Cadillac SUV for more than a week. Jones is arguing insanity. Jones told a sheriff's deputy that he was afraid of his son because he thought his son was going to kill him. Is it a made-up story, or is it a sign of legal insanity?
So when we started speaking about the children, he told us that he was afraid of the children. He said at home later that night, he said that his son Natan had threatened him, and threatened was his word. And the statement he attributed to Natan was, "When I grow up, I'm going to kill you." And then he told me that his son Elias said, "I'm going to," quote, "going to cut people up and feed them to dogs." And then, I was going to say, he started telling us about Natan messing with electrical outlets in the home, and he believed that Natan was, quote, "up to something," end quote.
And you challenged him at that point in time and said, "They're just kids. How can they pose a danger to you?"
Yeah, he did say that. I did ask him that, how the children could pose a danger to him.
And he told you that the kids were extremely intelligent.
He said they were extremely intelligent, and then he referred to the recent incident. Turned out there was an incident report with the sheriff's department that's been brought up where his youngest son, Gabriel, had walked away from the babysitter's house and been caught going up South Lake. They think maybe he was going to Saxcoff Elementary School. Timothy said this was not normal behavior for a 2-year-old, and he said this was an example of how intelligent the children were.
And that's why they posed a danger to him.
Yes, and he said this was a reason that he felt they posed a threat to him.
And he told you that he thought that the kids were conspiring to kill him?
Yes, he did. He said that he believed that they were conspiring to kill him on the night of August 28, 2014, and then he said that that's why he drove them to Walmart, said he abandoned them in the parking lot, and then drove away.
He had also told you that he thought that maybe Natan was up to something and was possibly experimenting with the electricity as a possible means to electrocute him in his sleep.
Yes, he referenced that the issue with the outlets, he believed that it was Natan attempting to find a way to electrocute him in his sleep.
We will talk about that changing story in just a moment. Also, a neuroradiologist testified that the defendant exhibited brain damage after a car crash in his teens. He said the damage likely caused mental health issues.
The yellow area is pointing to that black dot, and that's the area of hemorrhage. And there's another one here, and there's a third one here. There's at least 3 areas of hemorrhage. So, and this is not sort of expected because he has a skull fracture, and then he has these hemorrhages which are under the skull fracture, which are well seen on this sequence.
So the fact that the hemorrhages are visible in an old injury, what's the significance of that?
And hemorrhagic diffuse axonal injury, as we see here in Mr. Jones, is very unusual. Most patients that have head trauma do not have this. It's associated with poor prognosis. So you have to have a severe trauma, which we know he did because he has a large fracture there. These hemorrhages do over time. About 30% of them resolve. So it's likely that at the time this trauma occurred that he had more of these.
We've been talking about the damage to these areas of the brain. Can you tell us a little bit about what the significance of those areas are and damage to them?
Some of the symptoms that have been described following frontal lobe injury includes cognitive problems, lower intelligence, lower IQ, and then also problems with executive functions, with personality changes, risk-taking, disinhibition, and behavior spontaneity.
Another doctor confirmed that the brain damage likely caused mental health issues, such as the defendant believing voices in his head wanted him to kill himself. This next expert also addressed illicit drug use, saying it did not necessarily cause mental health issues.
Did you consider the possibility that what he has is substance-induced psychosis?
Yes, I consider that. We know that he started using spice a great deal, really, in the last 3 months before these events occurred. And so, obviously, one has to think about, well, then was the drugs the cause of this issue? Well, the first thing is that he told me that the drugs calmed him, that the drugs actually let him function. They quieted the voices, they reduced his irritability, they helped his moods, so he was able to actually function and go on. He was using drugs through that time, and people didn't think he was psychotic. He wasn't doing anything flagrantly psychotic, openly hallucinating in front of them, that sort of thing. So it wouldn't be as a cause of substances as I would see it from there. But to me, I think the biggest piece of evidence in that is that he has been treated for schizoaffective disorder, but basically schizophrenia, in the jail for 4.5 years with high doses of antipsychotic medicines. And there's no way substances would be causing you to have problems now, 4 years later. Additionally, my examination of him is absolutely consistent with someone with schizophrenia. But again, I think the fact that he's been treated in the jail for as long as he's been treated with antipsychotics says this is a real psychotic illness that he has. This is not caused by drugs.
The state suggests there is evidence of a cover-up here, which would tend to prove the defendant was sane. The defendant's internet activity included searches for mental health terms, plus this.
September 2nd, 10:35 in the morning, with a YouTube search. The string that was entered in the YouTube search was dog search for body in landfill. Followed up at 9:38 a.m. with another YouTube search for clean pool muriatic acid. And at 10:41, a YouTube search for muriatic acid burn. Followed by, at 10:43, a Google search for camping Columbia, South Carolina. At 10:46, there was a Google search. The key words that were entered were, what does no extradition laws mean? At 10:57, there was web history. The website was blogs.findlaw.com. The title page was 5 countries where no U.S. extradition treaty.
Back to the panel now for some quick discussion on this case. So Brian Buckmire, I got to ask about this. It's rare in a case like this, which I think is a strong case for the state, but it is rare to have a graphic illustration of an actual brain injury that you can couple with a mental health defense. That's really helpful for the defense.
Absolutely. And it is rare that you not only... The problem is many people walk around sometimes undiagnosed. So the fact that someone is diagnosed, they have the medical background, they have the ability to show, hey, here's a scan of the brain and this is an actual reason why there might be mental health issues, definitely helps the defense. The problem they're coming up with, I think, in this case is some of the deliberation that's actually seen and actually was given to the investigators as to how he actually killed these children. That's going to be something that's going to be very difficult, regardless of any kind of photo.
Jason Friedman, I got to ask about this changing story with the power outlets. First, he says, my son was messing with him. It caused a breaker to trip or something like that. So I disciplined him to the point he died. Then we've got this other version of the story. Oh, no. I thought my kids were going to electrocute me and kill me. And that's why I dumped them off at Walmart. And that's the only thing I did. How many times has this story changed?
The more the better for the prosecution, because every time he changes the story, it certainly strains the credibility of that argument. You know, keep in mind that he has a brain injury. Let's say he has mental illness. If I'm the prosecutor, I'm going to almost acknowledge that. But it's a huge leap to go from the mental illness to criminal legal insanity, not appreciating the conduct of your actions, not understanding right from wrong. And those internet searches, that is very, very strong. That suggests he knew right from wrong, and that's the test in South Carolina. This is going to be an interesting case. There's a possibility for one of 3 verdicts: guilty, not guilty, or guilty but mentally ill. So, gentlemen, appreciate the insight here on the debrief. We're going to kick you back to live coverage of the Winslow case in California. I will be back at 5:30 tonight to push that coverage into the evening. I'll see you then.